And a very good morning to you. John Fradgley from the Bell Legal Group, back with you for another program of The Law and You right here on 4CRB. As always, your opportunity to get free legal advice. All we'd like you to do is get on that phone as soon as you possibly can. The number 55208888, that number again 55208888. If you live south of the Tweed River, of course, you need to put 07 in front of the number. And if you want to send us a question by email, which we would deal with next week, you can do so. The email address is talkback@4crb.com. But unfortunately, we can't deal with emails that come through during the show because because we're live to air. There's not time to read the questions and deal with them. We don't want that dead air while questions are being absorbed. So if you don't mind, if the only way you can get a question through is by email, email today, and we will certainly deal with those questions next week. The email address talkback, all one word, @4crb.com. Otherwise, get on that phone right now. 55208888. Thank you to the people who called in last week to make for an interesting program, made all the more interesting by the presence of Dan O'Connor, who's an associate and a lawyer at the Bell Legal Group in the Wills and Estates team. And you may remember was talking about the difference between loans and gifts, and how it can be extremely important how you deal with money, for example, that you might give to your children, not only because that can have a real impact if, for example, the relationship between one of your children and their spouse breaks up and you've provided a substantial sum of money to assist them in buying into a home. If it hasn't been properly designated as to whether it is a loan or a gift, then it very well may end up being deemed to be a gift, in which case the money will 50% of the money, or perhaps even more, potentially could be lost to your child's spouse. So it's extremely important for that. And of course, the other area that Dan stressed too was in gifting money, you need to be very aware of the possible impact that may have on your pension, because as you would be aware, there are limitations on how much you can gift each year. You can give away $10,000 in 1 year or a total of $30,000 over 5 years. And I know of an instance where a lady gave a very substantial sum of money to her daughter without thinking through the consequences, and the result was that her old age pension was cut off, and she was unable to get the pension back for a period of many, many years. And of course, you can imagine what the financial consequences of that were. And worse still, when she realised the impact it was going to have on her pension, she asked the daughter to give her the money back so that she could use the money to live. And the daughter, who'd had her sign a deed of gift in relation to the money, refused to give the money back. Unsurprisingly, the relationship between mother and daughter is completely disintegrated, but it left the woman in great financial need. And so it just highlights how dangerous that can be. But enough of that. We've got Faye online. Good morning, Faye. How are you this morning?
Oh, good morning.
How can we help?
John?
It is indeed. How can we help you today?
Well, I'd like you, just one quick question, if
Sure.
I may. Does a will have to be registered?
No. In Australia, there is presently no provision for the registration of wills, and that's why it is so important that you keep your will in a safe place. And so if you make your will through a lawyer, we recommend that the will be kept in the document storage of the lawyer, a copy of the will kept at home with a clear notation of where the original is held, so that in the event that someone passes away, there's no problem in locating the will.
No.
And the other thing of course, is that lawyers will also or should also keep all prior wills as well, so that if there were a question about testamentary capacity in relation to the last will, or some question about undue influence, prior wills are held so that the copy of that will can be looked at to see what was provided, and if it is found that the person lacked capacity, or alternatively that there was undue influence in the preparation of that will, the most recent will, then the prior will is available to be considered by the court.
Thank you very, very much. I think you've explained it beautifully.
Okay, Faye, all the very best. And the time on 4CRB, it just keeps rolling along. 11 minutes past 9, past 10 on the Tweed, as we say a very good morning to Graham. G'day, Graham. How are you today?
Hello. Yes, John. I wonder if you could explain to me, please, what is a testamentary trust in a will? What does that do?
Right.
My mother's... Go
on. No, after you.
My mother's recently redone her will, and has given a copy to each of us children, and everything's in equal shares, which is fine. But each of the allocations and shares is in a testamentary trust, which I haven't seen before.
All right. Okay, well, look, probably by the sound of it, Graham, what may in fact have been used is what we refer to as a testamentary discretionary trust. A testamentary trust in its most basic form is a very simple thing. For example, if you have a will which says, I leave all my estate to my spouse, and if my spouse fails to survive, I leave it to our children, and your children are under 18 years of age, then they can't receive the benefit under the will, with the exception of provision that's made for maintenance, education, welfare and advancement. They can't receive the bulk of the money until they turn at least 18. And so that would be...
Well, that's not in this case.
No, but that would be a testamentary trust in its most basic form. Probably what your mother's done is included what's called a testamentary discretionary trust, and these are used to basically protect the assets from outside claims. So they're commonly used to protect assets that are being transferred, or the benefit of assets which are to go to children, for example, to protect those if there's a matrimonial breakdown between one of the children and their spouse. Then if the trust is properly structured, the assets in that trust can't be claimed by the family court as part of the pool of matrimonial assets, but they certainly can be regarded as a financial resource in the split up. So whilst the family court may not be able to make an order about the specific assets, they may be able to say, well, because you've got the benefit of these assets here, we're going to give a bigger chunk of what you and your spouse own. We're going to give a bigger chunk of that to your spouse. The other area would be, for example, if you have a child who's in a high risk profession, for example, perhaps they're an obstetrician or a gynecologist, or alternatively they're in a business that's a bit shaky, and there's a chance the business is going to run into financial difficulty and they're going to be sued by creditors, then placing the assets in a properly constituted and constructed testamentary discretionary trust will protect those assets from outside attack. Creditors would not be able to claim them, or a claimant, for example, in a negligence suit would not be able to claim.
Okay. So if a beneficiary, can a beneficiary themselves access the funds in the testamentary trust while it's in the trust?
It's up to the trustees of the trust. And one of the issues in relation to these trusts that is extremely important is to make sure that the at-risk individual, or the person being sought to protected, is as distanced as possible. So if, for example, you were to set up a testamentary discretionary trust which said, I appoint my son Bill as the trustee of the trust, and you make Bill the primary beneficiary of the trust, and you make Bill the appointor of the trust, trust,
Yeah.
well, you might as well not bother setting up a trust at all, because the court will regard that trust as the alter ego of that person, because effectively Bill has total control. So the steps that need to be looked at in the setting up of these trusts is who are the trustees, so that you can say, well, this person does not have total control. Who's the appointor? And the appointor of the trust is the person who has the right to change the trustee, and also who primarily benefits from the trust. So that all being said, they can still be structured in a way that the assets in the trust can be used primarily for the benefit of the beneficiary. The beneficiary. In any case, it would just depend on the circumstances of the beneficiary at the time. But the trustee does have a total discretion.
So, and the minute they take it out of the trust, it's open to challenge.
Absolutely. Well, it's open to attack. That's right. Yeah. So, if you take the money out, and I mean, quite often we do vest testamentary trusts. It may be that, for example, by the time the will is brought into effect, the beneficiary who was considered at risk is retired. It's been more than any adequate length of time where any claim might have been brought against them for some misadventure in business. Their marriage has shown stability over a period of many years, and the beneficiary says, look, I would really like the benefit of this money because I've still got a substantial mortgage on my home that I'd like to pay off, or something else I'd like to do, and the trustees may consider that. The other thing trustees can do in these trusts is, though, for example, if it was because there's a mortgage over the home, which there's no tax deduction for, the trustees might say, well, look, we'll replace the mortgage over your home to the bank with a mortgage, with a loan from the trustees, which is a registered mortgage but has a big difference. It may provide that it's interest free, which obviously would be a huge benefit.
All right, thank you for that, John.
Okay,
well
then, Graham.
Thank you.
All the very best. Time on 4CRB, just coming up to 17 and a half minutes past 9. That's, of course, past 10 down at our good friends on the Tweed. And we say a very good morning to Bill. Good morning, Bill. How are you?
Oh, very well. Thank you, John.
That's good. How can I help you today?
Under a will, we have 3 executors.
Mm-hmm.
Can 2 of the 3 make a decision to sell a property without the consent of the third?
No. The decisions of the executors need to be unanimous. Sometimes there might be provisions in the will that say that a majority decision is acceptable, but I don't believe that that would be legally enforceable. Normally the situation is that the executors must all agree.
Okay, thanks very much. That's good.
Okay then. But, Bill, just bear in mind that if the 2 executors want the property sold and it's reasonable that they do so, and the third executor is just being obstructionist, the other 2 executors could bring an application to the court. And if the third executor is being unreasonable in obstructing the sale of the property, it very well may be that the third executor will end up with a costs order against them from the court for putting the other executors to the trouble of having to bring the application to basically fulfill what was reasonable under the terms of the will. So it's not just a carte blanche that you can be obstructionist, or an executor in that situation can be obstructionist. They have to act reasonably at all times, and in the best interests, obviously in the best interests of the beneficiaries.
Is that a very expensive process?
What, to go to court? Normally what you'll find will happen is that if the recalcitrant executor is threatened with a court action, and the letter points out that if it's necessary to bring this application, that a costs order will be sought against the executor on an indemnity basis. If they go and get legal advice and it's quite obvious that they're acting unreasonably, then normally in most cases that I've been involved with, the executor sees reason and will in fact cooperate without the necessity of that application.
Right. Okay, I understand that. Yes.
All right then.
Right. Thanks very much, John.
Okay, Bill, all the very best. Time is just coming up to 20 minutes past 9. We'll be back after this word from our sponsor.
Harvey Norman South Tweed deliver anywhere, and they guarantee to beat any genuine competitor's price. And if you want good old-fashioned service, then Harvey Norman South Tweed is the place to shop. Their specialised staff will give you the best advice for your needs. With a great range of computers, furniture, bedding and electrical, there is no need for you to shop anywhere else. Why don't you go and see the friendly staff at Harvey Norman, South Tweed, because customer service is their priority.
Another sponsor.
Hey, true blue.
How you going, folks? Why don't you join me for my 50th anniversary tour, Winding Back.
Is it mom and dad? Living in the...
You never know, folks, might be your last chance to see my shows, my music, my songs, or just to say good day.
You can't fly, but I'm telling you, we can run the paths of a kangaroo.
I can't wait to see you there.
Tickets just $54. 8 p.m. Queensland time, March 6 and 7 at Twin Towns. twintowns.com.au.
A sponsor.
And this is the Law and You on 4CRB. It's your opportunity to get free legal advice, but we've only got, what have we got, 9 minutes to go. So please, if you have a question or a query that you'd like dealt with in this morning's program, give us a call right now, 55208888. Don't leave it to that last few minutes. Although we only had about 4 calls last week, I actually had to take one of those off air because it came in so late in the program, and we would always much prefer to receive your calls and deal with them on air, so we can not only help you with the answer to your query, but hopefully it might help someone else out there who's listening but unfortunately is not in a position to phone at this particular time. So 55208888 is the number. A couple of things that I wanted to talk about while we're waiting for any callers coming through, which have been highlighted to me over the last week. The first one is email scams, and just the need to be very, very vigilant about emails that you may receive, even if it's someone you're dealing with. So a classic example was during the week, we received an email from a tradesman who's been engaged to do some work. It's a reasonable sum of money, and attached to his email was a tax invoice, and the email gave the details of the bank account that the money was to go to. Now, there have been instances in Queensland and the other states of Australia where emails of that nature have been intercepted by people who are fishing for this information. And what they do is they set up a fake email account which looks almost identical to the one from which you've received the email, and then they intercept the email and they put into the email new details of the bank account the money is to go into, and then on forward that email, you still thinking you're receiving it from the tradesman or the person that you're dealing with. And so if you don't check but simply go ahead and pay, there is a risk, admittedly remote, the smaller the amount of money concerned is, but still there is a risk that you may have been the subject of a scam where incorrect bank details have been sent. And so what we did in this particular case was, my wife thought I was paranoid, and I probably am, but I rang the tradesman up and I said, look, we've received your email with the tax invoice attached. Thanks very much. I just want to confirm your bank account details. And I read over the because the name of the account was different to his business, and so therefore that was the other thing that made me think about it. So I just read the name of the account, read the BSB, read the account number. He confirmed it was all fine and all happy days, so no problem at all. But there have been a number of instances where lawyers throughout Australia have been subject to these scams, and there have been substantial sums of money that have been intercepted and sent to the wrong account, and some of those amounts have been in the hundreds of thousands of dollars. And certainly the Queensland Law Society, I know, and I'm sure the other law societies in Australia have been constantly issuing directives to lawyers that under no circumstances are they to accept account details received by email. And the other area where this also may particularly trigger a response is when you receive an email from someone that says, oh, look, just advising you that our account details have recently changed. Can you please pay the money to this account? And that should always be a red rag to say, well, hang on, I better double check these account details and make sure they're correct. And again, if you have a record, or if it's someone you're dealing with regularly and you have a record of their account and you've been sending money to that account for a long time, well, obviously you've got their records online in your banking details, and so you might receive the email and say, yes, that's from Bill Smith, the plumber, and you've already got his account details in your online banking, so you send the payment off. But if you've received an email saying that the account details have changed, make sure that you ring whoever you're dealing with to double check that the new account details are correct. You can then update your bank records, your online banking records, to make sure the payment goes to the correct account. But enough of that. We'll be back after this word from our sponsor.
Free information and education for seniors at the Seniors Health and Lifestyle Expo on this Thursday at the Albert Waterway Community Centre, Broadbeach Waters, right next to the library. No need to book. It's open from 9 a.m. until 1 p.m. Entry is free and a free sausage sizzle. Free advice on residential aged care, seniors travel, investment and insurance. Free hearing and eyesight checks, legal advice, mobility aids and advice from Centrelink, the City of Gold Coast Council. It's on this Thursday at the Albert Waterway Community Centre, Broadbeach Waters. Sponsor.
26 minutes past 9. The Law and You is the program. We've got time for one more quick question if you happen to have one out there. Otherwise, that will pretty well wrap up the program. But one thing that I made very brief mention of a couple of weeks ago and just reminded me that these changes are about to come into law in Queensland as from the 1st of March. And these are some fairly major changes to the powers of attorney legislation in Queensland. Now, under the old legislation, if an appointed attorney disposed of property owned by the principal, but that property was left under the will of the principal, then that benefit could potentially be lost to the beneficiary. And this is what's referred to under the law as ademption, that the gift under the will fails because the property, whatever it was that was being left to the particular person, no longer exists because it's been sold and therefore it's not there, or the bank account has been closed or whatever. And under the previous legislation, there was a risk of attorneys being sued by beneficiaries when if an attorney didn't bother to double check the will of the principal to see whether that property was left to anyone. And if that was the case, if they found that it had been left to someone, then the only way the attorney could sell that property without potentially leaving themselves open to a claim was to bring an application to QCAT. Well, the law has been changed, or the law will be changed from the 1st of March, so that in the future, if that happens, then the beneficiary will be entitled to the same interest in any surplus money or other property arising from the sale or other dealing with the property to give effect to the testator's intention before they lost capacity. So that's one good thing there. The other change that I did mention last week, the week before, just briefly, was that under the existing legislation, the principal must say that they understand the nature and effect of the power of attorney document. Now they're required to specifically acknowledge that they've freely and voluntarily entered into the document. I mean, I think it goes without saying that a person should freely and voluntarily do so, but I think that's also to overcome situations where people have been coerced into signing powers of attorney. If a lawyer is getting someone to sign a power of attorney, they will never allow the attorney to be present while the power of attorney is being signed, so that there's no possibility that can be done. There have also been changes made to the conflict transaction provisions under the legislation to better define what are and are not conflict transactions. And QCAT's also been given greater power to order attorneys, be they former or otherwise, who fail to comply with their obligations under the power of attorney to pay compensation to the principal or the principal's estate. So some fantastic changes to the law in that area, which will undoubtedly protect people to a far greater extent. I'm John Fradgley from the Bell Legal Group. It's been great to be with you this morning for another program of The Law and You. I'll look forward, of course, to being back with you again next week. But as always, until then, from me, it's goodbye and God bless.